This is Chapter 7, Section 1, Judicial Branch. Article 3 of the Constitution establishes the judicial branch of government, and it consists of the Supreme Court, lower federal courts, and lower federal courts. And what it specifically says in Article 3 is that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time be ordained and established. So it specifically says there's a Supreme Court, which we have, and there's lower federal courts, and that can be established as Congress sees fit. So what the judicial branch's purpose is, like we said, executive branch carries out laws, legislative makes laws, judicial branch applies the laws of the United States to specific situations. So, for example, a city is not allowing a church to be built, the courts of the judicial branch will decide if this goes against the freedom of religion, which is a law in the Constitution. That's what the judicial branch does. So all the courts that are part of the United States judicial branch are referred to as federal courts. And there's some types of federal courts. The Supreme Court, which is the highest court in the United States. There's appellate courts, and there's district courts. Appellate courts of appeals, and the lowest courts are district courts. So you can see here, district courts, there's 94 of them. If you don't like what happened there, you can go to the Court of Appeals and then to the Supreme Court. Jurisdiction. That refers to whether a court has the power to hear a particular case first. If courts did not exercise the appropriate jurisdiction, pretty much any court in the United States can hear any case anywhere, and it would get confusing. So there's strict laws of who has what court has jurisdiction where. State courts are limited to the boundaries of each state, so they only have jurisdiction within their state. But federal courts cover the whole United States. So there's 94. You can kind of see it's faint, but see how Oklahoma is like separated and Texas is separated. So there's 94 federal district courts. You can see Pennsylvania is divided up in 3. And how really they're divided up, semi due to population. There's some other factors, but that's just how they're divided up. And then within those 94, there's 12 district court of appeals. Cases where the federal courts have jurisdiction, where they hear it first. Cases that involve constitutional questions, like the city would not allow a church to be built. Would that go against the freedom of religion? That would be a constitutional question and would go to a federal court. Cases involving federal laws, laws passed by Congress, if it goes against that, that would be going straight to a federal court. Cases in which the federal government is a defendant. So sometimes the federal government does get sued by people, and that goes to a federal court. Cases involving people from different states, and it's worth more than $75,000 in the dispute. Also, ships at sea, any of those kind of cases, what happens out at sea, since it doesn't happen in a state or anything like that, that goes to federal courts as well. And also cases involving ambassadors of foreign representatives. Anytime ambassadors come here, maybe they don't do what they should, blah blah blah, that all goes to federal courts. So courts with the original jurisdiction determine the facts in a case, and that's where the trial happens. They're called trial courts. So a trial, that's when you have a jury, judge, the defendant and the plaintiff, and they present their cases to the judge and the jury during proceedings. The federal court system, in the federal court system, the district courts, the lowest level, is where the trials happen. After a trial court or in the district level, either the plaintiff, the person who brings the case, or the defendant, the person accused, um, that needs to defend themselves in the district court, they may appeal their case to a higher court, which is an appeal just means apply to a higher court for a reversal of a decision. That goes to the Federal Court of Appeals for review to review the decisions of the Federal District Court. No trial is held there, but is reviewed by a panel of 3 judges. The executive branch of government has power over the judicial branch by the power of appointment. So it's all about those checks and balances. Not one branch of government is more powerful than the next, and really how to keep the judicial branch in check is that the executive branch has the power to appoint all the judges. The President of the United States specifically appoints all federal judges. The Senate, this is how the legislative branch kind of puts their checks in the judicial branch. The Senate must approve all the appointments made by the president. Usually, the President of the United States appoints judges that share the same political beliefs as themselves and philosophies as they do. Like President Bush, he's a conservative. He would pick those who are the like-minded conservatism. You know, when President Joe Biden becomes president in a few days here, he'll appoint judges that are democratic in nature. And since judges are appointed for life, a president can have great impact on the judicial branch because these people serve for many, many years. The judicial branch can check the executive branch with the process of impeachment. So even though the legislative branch brings upon the impeachment of a president, the Supreme Court can declare acts done by the president as unconstitutional, which may lead to an impeachment. Many cases have been brought to the Supreme Court about presidential actions. You know, part one was that President Nixon, it was involving President Nixon's power as president. Was it against the Constitution with his executive power going too far? So that was one case brought to the Supreme Court. And the Chief Justice of the Supreme Court, our current one, John Roberts, he presides over presidential impeachment trial. So the legislative branch, how they can check the judicial branch is by passing laws that overturn Supreme Court decisions. So even though the Supreme Court can only make laws unconstitutional if a court case is brought up to the Supreme Court. So they can't just start ruling things unconstitutional without a case. So in that meantime, before a case is brought to the Supreme Court, the Senate makes all kind of laws, and it's not until these laws are challenged that the judicial branch has anything to do about it. The judicial branch checks the legislative branch by judicial review. Judicial review is reviewed by the Supreme Court to determine laws passed by Congress are unconstitutional. But like I said, that has to be done by a case being brought to the Supreme Court. Roe versus Wade, that was a Supreme Court case that overturned abortion laws in the United States. Even though the United States banned abortion, the Congress did. Roe versus Wade said that no, abortion laws are okay in the United States. So that's one way that, it might take a while, but to judicial review, the judicial branch can change laws and by saying that certain laws are unconstitutional. And that ends Chapter 7, Section 1 for Civics.